Welcome LML 4807 students to Lesson 5 Part 1. Today we will be discussing the bank-customer relationship. Let's first take a look what is meant by the bank-customer relationship. The bank-customer relationship is created with the opening and the operation of a bank account. The relationship entails mutual duties and obligations. What I'd like to mention here is the bank is a separate legal person and can therefore acquire rights and incur obligations, own property and sue and be sued. As a bank has no physical existence, it is represented by the bank managers and appointed officials to conclude contracts and perform juristic acts on its behalf. The customer, in the context of the bank-customer relationship, generally refers to a person who has a bank account with the bank. Keep in mind that the term customer cannot be interpreted to only mean a person. It could be a variety of different persons, including companies, insolvent estates, municipalities, or even another bank. Now we can move on to see what is the legal nature of the bank-customer relationship. As you can see, it lists that the legal nature of the bank-customer relationship is based on contract. So when considering what is meant by this relationship, it is important to remember that the relationship is fundamentally based on contract concluded between the bank and the customer. The relationship is multifaceted as it exhibits elements of different types of contract. The type of contracts between the bank and the customer is dependent on the nature of the service that the bank offers to the customer. The next slide provides a few examples of how such relationships could be classified and illustrates that the type of relationship between a bank and a customer depends on the service offered by the bank to the customer. As you can see from this slide, it gives examples of classification of the bank-customer relationship. The relationship is often complex, overlaps, and does not always fit in comfortably into any single category of contract. To establish the relationship between a bank and a customer, it is suggested that each case is examined with regard to the specific legal relationship that exists in a specific case. Now let's consider the contract of mandate. As you see, it is in bold on the top left. This is where the bank agrees to carry out one or more banking services for the customer. The relationship between a bank and its customer invariably incorporates mandate. Now let's consider the contract of depositum, as mentioned on the top right of the slide. Where a customer deposits valuables with a bank in a safety deposit box, a contract of depositum is established. However, where the customer hires a safety deposit box to store valuables, which is more modern current practice, the box is rented out and a contract of lease comes into being. Note that this will be dealt with in more detail in Lesson 6. Now let's look at the example of payment intermediary. A bank can act as a payment intermediary in respect of credit cards, stop orders, debit orders, and bills of exchange. Mutuum is also listed in bold on the left side of the slide. Mutuum means loan for use or loan for consumption, where the customer deposits money with a bank or where the customer has a credit balance in a current account, a relationship of mutuum exists. Mutuum in particular will be discussed in the slides that follow in this lesson in more detail. Further, a bank can act as a lender and financier when offering overdraft facilities and other loans. A bank can also act as a borrower of money when you deposit money into a bank account, such as a fixed deposit, savings, credit card, or a current account. A bank can also act as a collection agent and as an administrator of estates. A relationship of debtor and creditor arises between a bank and customer regarding deposits. Where a customer's balance is in credit, the bank is the debtor. Where the customer's account is overdrawn, the roles are reversed, and the bank is the creditor and the customer is the debtor. This relationship will also be elaborated on in the slides that follow in this lesson. Lastly, a bank can also provide advice and act as a representative when it concludes a contract on a customer's behalf. The bank may also act as both a mandatory as well as a representative, such as when it furnishes investment advice to its customer and also enters into an investment contract with a third party on behalf of the customer. As you can see from these examples, is that the relationship between a bank and a customer is multifaceted and dependent on the service offered by the bank. A few of these listed above will now be discussed individually in the slides that follow. In the next two slides, we will discuss the bank-customer relationships of mandate, mutuum, and the relationship of debtor and creditor in more detail. In terms of the contract of mandate, the bank agrees to carry out one or more banking services for the customer. The bank, as mandatory, undertakes to observe good faith in the handling of the business entrusted to it by its customer, the mandator. When considering mutuum, which is loaned for use, it comes into existence where the customer deposits money with a bank or where the customer has a credit balance in his or her bank account. The bank becomes the owner of the money deposited with it, and the client has a claim against the bank for a similar amount of money at a later stage. The principles underlying the contract of mutuum clearly illustrate why the relationship between a bank and its customer is one of debtor and creditor, and the relationship of debtor and creditor will be discussed on the next slide. Now let's consider the relationship of debtor and creditor. When a customer makes a deposit in a bank account, the bank becomes a debtor with regard to that amount. Where the account is overdrawn, the roles of the parties are reversed. The bank is then the creditor and the customer the debtor. However, the customer is not an ordinary debtor since the bank is under no obligation to contact the customer and repay him or her. Instead, the customer is required to make the demand for repayment of his or her money. The customer merely acquires a personal right to payment of the amount standing to the credit of his or her account. The demand for repayment is made in the form of the customer withdrawing the money or instructing the bank to make payment to a third party. This concludes for our lesson today. This was Lesson 5, Part 1. In Lesson 5, Part 2, we will address the bank's duty of care, the bank's duty of confidentiality, as well as the bank as the owner of the monies deposited.